Hello, this is Owen from Family Mediation Ireland. The following is a short video presentation to explain to people how our family mediation process works. Firstly, I'll start out by going through some of the core principles behind mediation. Mediation has several key elements to it, the first of which is that outside of financial disclosure between the two different sides, whatever takes place in mediation is treated as confidential. Also, both sides can confide information in the mediator that is confidential, that they do not necessarily want the other side to the dispute to find out about. This allows the mediator to be conscious of any problems or issues in working the parties around a dispute. The second point, which is important, is that mediation is conducted on the basis of impartiality. That means that the mediator is impartial and will not side with one or other side in the dispute. It also means that the mediator will not make any judgments and will not be acting as a judge to the mediation. In effect, the mediator is only there to facilitate the mediation process. Nor, for that matter, is the mediator seen as a legal advisor and won't be giving either of the sides legal advice. The mediator is merely there to help people find their own solution, and the mediator will encourage the parties to find their own solutions to their own problems. And ultimately, the mediator will be pushing towards a meeting of minds whereby the parties come up with their own solutions to their own difficulties. Mediation has some obvious benefits, the first of which is it's cheaper than protracted court proceedings and can prove to be very cost effective in terms of resolving disputes. Mediation also allows parties to build better relationships and communication paths. In other words, when the mediation process has been completed, parties will be able to move forward using a new means of communication that will be positive. People generally after court cases find talking very, very hard, whereas mediation helps people develop new means to communicate. It's an open process, and this is based upon transparency, whereby where financial disclosure is made in the mediation process, both sides openly declare what their circumstances are, and it's based on principles of transparency and openness. Unlike the public mediation service, which has a tendency to have backlogs from time to time depending on where you are living, there are no backlogs in the private family mediation service, and many private family mediators around the country do not have backlogs. Mediation also facilitates parties to discuss and raise issues that otherwise wouldn't be raised in the standard litigation model of the courts process. For example, sometimes in the district court, judges are reluctant to have children involved in the court process or take the views of children on board, and whereas the welfare of the children are paramount, there's no requirement for the court to take the views of the children into account. Mediation, on the other hand, can allow the views of the children to be incorporated if both the parties and the mediators agree to that. The next section I want to take a look at is the actual physical appearance of the mediations. Generally, this is divided between two types. The first type is the joint sessions, where the parties are together for the mediation session, and the second one is where the parties are separate and in different rooms. With the first scenario, the two mediators will meet with both of the parties together to conduct the mediation. If the parties need to take a time out, or the mediators need to take a time out of the process, they can go into a relief room and relax for a while before re-engaging in the process. Many family mediators believe that this is the best way to conduct mediations. There is the second means of conducting mediations, which is where both parties are in two separate rooms. Maybe it's not possible for them to sit down together, maybe the difficulties are to that extent. The mediators will then work between the two rooms in terms of trying to find a solution for the parties. They will work on their own solution, the parties directly, and the mediators will facilitate them in finding this, and they will go backwards and forwards between the two rooms until the parties hopefully reach a memorandum of understanding. Just by way of a chronological explanation as to how the process works, it starts out by the mediators meeting with each of the parties in person. It then moves on to the first joint session. The parties will then conclude a financial summary, which is an open document. It's important to point that out. Even though everything else in the mediation is confidential and the memorandum of understanding itself is not legally binding, the financial summary is an open document and could be used in court proceedings in future if the mediation process did break down. It's just important to point that fact out. Also, the parties are obliged to, after that, to go into different sessions, and they can be completed on either a joint or on a single basis. and the parties may then, if they've succeeded in concluding a memorandum of understanding at the end of the process. That's not a legally binding document, but the parties can take it to their respective legal advisors and they can draw up a deed of separation, or they can formulate it into a consent court order. It's recommended that before, during and after the mediation process that the parties take legal advice, and that they certainly take legal advice before executing any documents as part of the mediation process. In the actual process itself, there are various different tools that we used, amongst which some of them are brainstorming, whereby both parties are encouraged to come up with solutions together themselves over multiple scenarios to see if they're to evaluate all potential avenues of resolve. Also, there's a best case scenario or worst case scenario model, where parties in private by the mediator are asked to examine what their hopes and fears are about the process, what their best case scenario in terms of what they're looking for, and what their worst case scenario is. Also, the parties have to examine closely their needs versus their wants. In other words, what do they really require out of this process, and what maybe is more superficial and not necessarily a need. As part of the process, mediators will use a flip chart to help parties visualize their problems and also to visualize potential solutions. And the entire mediation process, of course, is based on constructive dialogue, where both sides engage each other in a positive and an adult-like manner, and they refrain from using abusive language or resorting to name-calling in the mediation sessions. Of course, if things are getting tiring inside and it's not working out so well, parties also have the ability to call a timeout, where they can step out of the process, take a breather, and then re-engage whenever they're happy to go back in. If you require any further information, you can check out our website, which is familymediation.ie, and if you have any specific queries, you can send them on to us via email at info@familymediation.ie. Thanks very much.